All right, welcome back to the deep dive. Today we're diving into the False Claims Act, more specifically, the statute of limitations and when that clock actually starts ticking.
Yeah, we're looking at Cochise Consultancy, Inc. et al., United States, Exrel, Billy Joe Hunt. It went up to the Supreme Court.
Oh wow. Okay, so this is the big leagues.
Yeah.
So what happened? Like, what was the end result of all this?
So the Supreme Court ended up agreeing with the 11th Circuit's ruling.
Okay.
Which basically said that, that longer statute of limitations under the False Claims Act, that one based on the government knowing about the issue,
Right.
They said, yeah, that's available. Even when the government's like, nah, we're not going to get involved in this case.
Okay, so even if the government doesn't step in, that longer time frame still might apply.
Exactly. However, there's a catch.
Oh, there's always a catch, isn't there?
Right. They also said that it's the government's knowledge that matters. It's not the whistleblower's knowledge that starts the clock ticking.
So the whistleblower could know, but if the government's in the dark...
then that longer period could still be in play.
Interesting. Okay, so let's back up a little bit because I think some people might not be super familiar with the False Claims Act. I mean, I know we talk about it a lot on the show, but, just as a refresher, what is it all about?
All right. So the False Claims Act, it's basically this powerful tool. It's there to help the government combat fraud.
Makes sense, yeah.
Right. So let's say you have these individuals or companies who are trying to cheat the government out of money, by submitting these false claims. Like, I don't know, maybe they're overbilling on a contract or they're committing some kind of healthcare fraud.
Yeah.
The False Claims Act lets private citizens, they act as these relators, and they can actually step in and file these lawsuits on behalf of the government.
Oh, so it's like they're kind of deputized to fight fraud in a way.
Exactly. And the idea is to encourage people, especially those who might have inside knowledge of this fraud, to come forward, even if the government is completely unaware of what's going on.
That makes sense. You give people an incentive to come forward, especially if they might be hesitant otherwise.
Exactly. And if the lawsuit is successful, the relator, that person who brought the suit, they get a portion of the recovered funds.
Oh, so there's a financial incentive too, on top of doing the right thing.
Right. And of course, the government can always decide to jump in and take over the case if they want to.
Got it. So that brings us back to these two different timelines, these two different statutes of limitations that we were talking about earlier. Why are there two?
So under the False Claims Act, in Section 3731B, there are these two potential deadlines for filing these lawsuits.
Okay.
The first one, in subsection B1, it's pretty straightforward.
Laid on me.
You've got 6 years from when the violation happened to get that lawsuit filed. Boom. Simple.
6 years. Okay.
But then there's the second one, subsection B2, and it's a little bit more complicated, a little bit more nuanced.
Okay. How so?
This one says you can file a lawsuit up to 3 years after a certain government official, like someone who is specifically charged with responsibility to act, knows or should have known about the fraud.
So not just any government worker, someone specific.
Exactly, someone with direct responsibility. But there's another wrinkle. Even with this 3-year window, you absolutely cannot file the lawsuit more than 10 years after the violation.
Okay, so 10 years is the absolute drop-dead deadline.
Exactly. So Congress put these two deadlines in place to kind of balance a couple of things. One, they want to give enough time for these complicated frauds to be discovered.
Sure. Sometimes these things take a while to unravel.
Right. But at the same time, they don't want these legal threats just hanging over people's heads indefinitely.
Yeah, that would create a lot of uncertainty for everyone involved.
Exactly. And this shorter period, the one tied to the government's knowledge, that reflects the idea that if the main victim, the government, if they know about it, well, then the clock should start ticking faster.
That makes sense. So let's talk about Cochise. What were the specifics of this case? What was the alleged fraud, and when did this all go down?
Okay, so in Cochise, the relator, his name was Billy Joe Hunt. He accused this company, Cochise Consultancy, of some shady dealings.
Oh, Cochise Consultancy. What were they doing?
So they were providing security services over in Iraq, but Hunt claimed they were soliciting false payment claims to the government, basically trying to overcharge them for their work. And he alleged this went on until early 2007.
Early 2007, okay.
Yeah.
And when did Hunt finally blow the whistle? When did he come forward and say, hey, something's fishy here?
So he claims he first spilled the beans to federal officials during an interview on November 30th, 2010.
2010.
Yeah. And here's the thing. That interview, It wasn't even about Cochise.
It wasn't.
No, Hunt was actually being interviewed about a totally different contracting fraud case.
Yeah.
And he just happened to mention this Cochise thing while he was there.
Oh, wow. So it was just a side note.
Yeah, basically. And he didn't actually file his lawsuit against Cochise until November of 2013.
Okay, so 2013, that's well over 6 years after the alleged fraud ended back in '07. So that's where this whole statute of limitations thing comes into play, right?
Exactly. So Cochise, they're like, hold up, this lawsuit's way too late. They argued that under that standard 6-year statute of limitations, the one we talked about, Section 3731B1, the time had run out.
Yeah, seems like a pretty straightforward argument from their side.
Right. But Hunt, he had a different take. He argued, no, my lawsuit's still good. I filed it within 3 years of when I told those officials back in 2010. So he's relying on that B2 provision, the one tied to when the government official knew or should have known.
Right, the knowledge-based one. So what did the lower courts do with this?
All right, so the district court, they initially sided with Cochise. They dismissed the whole case. They looked at a few different ways to interpret how those two parts of the law fit together. Like one idea was that knowledge-based one, B2, it just doesn't apply to whistleblower cases where the government doesn't get involved.
Interesting.
Another one was that, yeah, it does apply, but the official they're talking about is the whistleblower themselves.
Oh, I see.
So they rejected those first two. Then there was this third one, the one the 11th Circuit eventually agreed with, and that one says, okay, B2 does apply, and the clock starts when a real government official is in the know.
So not the whistleblower, an actual government person.
Right. But the district court, they didn't like that one either. They said, nope, Hunt's lawsuit is too late based on those first two interpretations.
Okay, but then the 11th Circuit came in and said, hold on, we disagree.
Exactly. They reversed that decision. They sided with that third interpretation. They said B2 does apply even when the government doesn't jump in, and it's the government official's knowledge that triggers the deadline.
Okay, so now we've got a disagreement between the district court and the 11th Circuit.
Yeah.
This is where the Supreme Court steps in, right?
Yeah.
To settle this whole debate.
Yep. That's when the Supremes get involved.
So what was their thinking? Why did they agree with the 11th Circuit that this B2 could apply even without the government taking over the case?
The Supreme Court really went back to basics.
Got the basics.
They focused on what the statute actually says. They said, look, the law is clear. Section 3731B says both of these deadlines apply to a civil action under Section 3730.
Right.
And they pointed out that both lawsuits started by the government itself under 3730A and those filed by whistleblowers under 3730B, they're both considered civil actions under Section 3730.
Okay, I'm following so far.
So the Supreme Court's like, well, it's simple then. If both types of lawsuits are covered by 3730, then both of those deadlines in 3731B have to apply to both types of cases.
It's like a logic puzzle almost. If A equals B and B equals C, then A equals C, right?
Yeah, exactly.
So did Cochise try to argue against this? Did they try to say there's a reason to treat those two types of lawsuits differently when it comes to the statute of limitations?
Oh, they did. They definitely tried. Cochise said, look, that 3-year limit in B2, the one that starts when someone knows the facts, that's there to give the government more time when they're out of the loop.
Okay.
They were basically trying to say that, sure, a whistleblower lawsuit is a civil action under Section 3730 for that 6-year deadline, but not for this 3-year one based on knowledge.
So they're trying to have it both ways.
Exactly. But the Supreme Court wasn't buying it.
They weren't persuaded.
Nope. The court said, hold on, we have this principle of statutory interpretation. When a phrase is used in a law, we assume it means the same thing every time it pops up.
Consistency is key.
Exactly. And they cited other cases to back this up. Courts don't like interpretations that make the same words mean different things in the same law.
Right. That would make things way too confusing.
Exactly. So the Supreme Court's view was you can't just pick and choose when a whistleblower lawsuit is a civil action under Section 3730. It either is, and both deadlines apply, or it isn't. And they said, it is.
Okay. Pretty clear ruling there. Now, I know Cochise also tried to use a previous case, Graham County, to support their argument. What did the Supreme Court say about that?
Right. So Graham County, that was an earlier case where the court had to figure out which deadline applied to retaliation claims under the False Claims Act.
Okay.
And in Graham County, the language of the law was kind of ambiguous. There were two ways you could reasonably interpret it. So in that case, the court ended up interpreting civil action under Section 3730 a little bit more narrowly.
Okay, so they had some wiggle room there.
Right. But the Cochise court said, look, Graham County is different. Here the language is clear. There's only one reasonable way to read it.
No wiggle room this time.
Right. They basically said, when the law's clear, our job is done. We don't go looking for other interpretations.
Okay, so they stuck to the plain language of the law. Now, what about this potential outcome where a whistleblower might actually have more time to sue than the government would if they had brought the case themselves? Doesn't that seem a little unfair?
Yeah. The court acknowledged that it might look a little strange in certain situations.
Also.
So imagine the government knows about a fraud right from the start. They'd generally have 6 years to file a lawsuit.
Okay, 6 years.
But what if a whistleblower also knew about it from day one, but the government was kept in the dark? That whistleblower could potentially have up to 10 years to sue.
Wow, that's a big difference.
Right. But the court said, yeah, it's odd, but it's not completely crazy.
So they acknowledged it, but they didn't see it as a deal breaker.
Exactly. Their logic was that it makes sense to give more time when the government, who's really the one being hurt, is totally unaware of the fraud.
Okay, so the government gets a little extra leeway because they're the victim.
Right, and they pointed to a previous case where the court said that just because a result seems odd, it doesn't mean you can ignore what the law clearly says, especially when there isn't another reasonable way to read it. And for someone considering this, it means even if the government was aware earlier, your independent knowledge and later filing could still be okay. But on the other hand, for defendants, it highlights how important it is to understand when the government actually found out about the fraud, regardless of when a whistleblower pops up.
Right, that government knowledge is key. Okay, so we've established that B2, that longer deadline, it can apply to these whistleblower cases even when the government doesn't get involved. But the second big question is, who counts as the official of the United States? Whose knowledge starts that 3-year clock ticking? Cochise argued that it could be the whistleblower themselves, right?
Right. That was their backup argument. They basically said, hey, if the government doesn't jump in, the relator, the whistleblower, they become the official of the United States charged with responsibility to act. Which, if that's the case, means that 3-year clock starts ticking when they knew about the fraud.
Interesting argument. I mean, if the whistleblower knows, shouldn't the clock start regardless of whether the government knows?
Yeah, that's a good point. It seems kind of intuitive. What's the counter to that?
Exactly. What did the court say about that?
They shot that idea down. They gave a few reasons why a private relator, a whistleblower, just can't be considered the official of the United States for this purpose. For one, a whistleblower simply isn't a government official in the traditional sense. They aren't appointed or employed by the government. They even pointed out that the very section of the False Claims Act that lets these whistleblowers file lawsuits, it's literally titled Actions by Private Persons in 3730B.
Okay, so the law itself makes that distinction between government and private citizens.
Exactly. And then they zeroed in on the specific wording, the official charged with responsibility to act in the circumstances. They said using the like that, it suggests Congress had a particular government role in mind, not just any random person who knows about the fraud.
Okay, so it's got to be someone specific within the government.
Right. Now, the court didn't actually say which government official they thought this referred to, but the government argued it's likely the Attorney General, or someone they designate, because the Attorney General has this duty under the law to investigate these Commercial False Claims Act violations.
Right, so it's someone with a very specific legal obligation.
Exactly. But the court's point was, regardless of who that official is, the use of the official means there's a specific governmental responsibility, and a whistleblower, a private citizen, just doesn't have that.
Okay, I'm with you. And what was their third reason for rejecting Cochise's argument?
Their third point was that whistleblowers aren't actually charged with responsibility to act in the same way that a government official is. They can choose to file a lawsuit, but they're not required to investigate or prosecute these cases.
Right. It's their option, not their duty.
Exactly. So the Supreme Court drew this bright line, that longer deadline based on government knowledge. Yeah, it's on the table even when the government sits it out. But it's the government's knowledge that matters, not the whistleblowers.
Okay, so the takeaway is that the government gets the benefit of that extra time because they're the ones being harmed.
Exactly. The court's decision really clarifies this whole issue. It tells us that whistleblowers in these non-intervened cases, they might have more time to file a lawsuit thanks to that longer statute of limitations. But it also makes it clear that the whistleblower's knowledge doesn't start that clock.
Right. It really all boils down to when the government became aware of the potential fraud.
Exactly. And this prevents those situations where the clock starts ticking before the relevant government agencies even have a clue. And don't forget, these whistleblower lawsuits, they're often the main way the government discovers these big frauds. So the rules around them have some pretty real consequences.
Yeah, this is about protecting taxpayer dollars, ultimately.
Exactly. So thanks to Cochise, we now have a much clearer understanding of how the statute of limitations works when the government decides not to step in. Now, stepping back, what do you think this means for the big picture?
Well, I think this decision shows how Congress has tried to strike this delicate balance with the False Claims Act. They want to encourage people to come forward with this crucial information, but they also need clear rules about when those legal actions can be taken. And Cochise helps to navigate that balance.
Definitely. And it raises these ongoing questions about the best way to ensure that justice is served in a timely manner and that we're effectively catching those who are trying to cheat the system.
Right. Absolutely. Now, for our 10th chair segment, let's put you in the Supreme Court's shoes. Imagine you were hearing the arguments in Cochise. What would your opinion have been?
Okay, so sitting on that 10th chair, looking at everything.
What's your verdict?
I'd have to side with the majority. The language of the law is pretty clear to me. It says 3731B applies to a civil action under Section 3730. And there's just nothing there that says we should exclude these whistleblower lawsuits when the government doesn't intervene. If we did that, we'd be adding something to the law that just isn't there.
Okay, so you're sticking with the text.
Exactly. And that argument that the whistleblower is somehow a government official, that doesn't hold water either. The law itself separates actions brought by the government from those brought by regular folks. To say a private citizen is the same as a government official with a specific duty, that's just stretching things too far.
Yeah, that seems like a bit of a leap.
Right. Now, I get that this could lead to some situations where whistleblowers have more time than the government, but I don't think that's a crazy result. Remember, the whole point of the False Claims Act is to get people to report fraud. And if giving them a little extra time when the government's in the dark helps with that, I think it serves that purpose.
So you're saying it's a worthwhile trade-off?
Yeah, I think so. Plus, the government, the one actually being harmed, they benefit from that extra time. So I'd say that B2 applies to these non-intervened qui tam cases, and a whistleblower isn't the official of the United States. That keeps things clear for future cases and stays true to what Congress wrote.
All right, a compelling argument from our 10th chair. And that's our deep dive into Cochise v. Hunt. This case really highlights the important role that whistleblowers play in fighting fraud against the government. And it also shows how complex these legal issues can be.
Yeah, this case is a good reminder that procedure really matters. Those seemingly small details in the law, they can have huge implications.
Absolutely. We'd love to hear your thoughts on this case. What do you think about the balance between encouraging whistleblowers and ensuring fairness to defendants? Let us know in the comments.